While an initial call should be with the lawyers to discuss the virtual mediation process, followed up by an email request, the mediator should also arrange another call with the lawyer and client to discuss the list that we have just gone through, and to ensure that the client understands the virtual mediation process and the questions you want them to start to consider. In particular, stress that they should start exploring with their lawyer their interests, as well as an assessment of their worst and best case outcome and why they feel that way.
Now, another very important consideration is the applicable law. And here, this is where arbitration gives you a complex array of different laws that have different rules in different regards. So please pay some attention here. When it comes to the applicable law, on the substance, the parties typically put that in the contract. This dispute shall be resolved in accordance with the laws of the state of New York, in accordance with the laws of England and Wales. You agree on an applicable law that will apply to the substance of the dispute.
It is essential for the tribunal to establish a procedural timetable at the outset of the arbitration, which is to be recorded in the procedural order number 1. Most of the time, arbitration legislation does not address the contents of the procedural timetable for the arbitration. Such matter is left to the parties' agreement, or when the parties cannot agree on those matters, it is left to the tribunal's directions, except for the mandatory time limits set out in arbitration statutes. Also, very few arbitration agreements deal with the procedural timetables for the arbitration. Most institutional rules contain time limits for the parties' initial pleadings, such as replies and counterclaims, but do not specify the timing of any further submissions, so they need to be decided.